This lecture is an introduction to boundary resolution. If you ever heard the saying, this is a test, this is only a test, I will use that analogy to introduce this module as this is an introduction. It is only an introduction. So this topic is what makes land surveyors different than simple measurement takers, mathematicians, GIS professionals, and even engineers who understand coordinate geometry and math and measurements. We're talking about boundary resolution. The term means that surveyors resolve boundaries. We resolve issues surrounding boundaries when possible. And we form a defensible professional opinion of where those boundaries lie. Now, I want to stop for a minute and make reference to a book that has several editions called Evidence and Procedures for Boundary Location. Curtis Brown and another gentleman wrote this years ago. It was later, Curtis Brown became like the sole author, and then he brought in Donald Wilson and Walt Robillard. Now, I have met and had conversations with Donald Wilson and Walt Robillard, and I've even worked on a couple of cases with Walt Robillard in years past. His grandson, Tony Nettleman, who graciously let us use one of his videos in an earlier module, is now a co-author, and Mr. Brown has been dropped from the authorship in the later editions because Mr. Brown's deceased. Now, so many people, so many courses use evidence and procedures for boundary locations. Some have asked, why am I not using evidence and procedures in this course? So the reason is that in my personal analysis, the book is more geared towards finding ancient boundaries. And by ancient, I mean like old grant boundaries, old original GLO, USPLSS boundaries, boundaries from the colonial era up through perhaps 100 years ago. You got to keep in mind that that was where the challenging work was when Curtis Brown started writing the book, and when Don Wilson and Walt Robillard came along to make their contributions. If you read the book, or at least go through it, you'll find that they spend a great deal of time, and I have the highest reverence for this book, I really do. They spend a lot of time going into evaluating old tree blazes, finding charcoal in the ground to serve as evidence of where a wood post may have been set in the 19th century. Now, the book and its material and its treatment of these things is totally accurate, very established, well respected and accepted nationwide in the surveying community. But I've been doing this for 37 years, and I've never tried to determine where an original wood post was set by doing charcoal analysis. I have looked at millions of tree blazes and hacks, but they were more than likely not from the original district surveyors between 1807 and 1832. They were where more recent surveyors had marked or remarked those lines. So a lot of what is in there is totally accurate and great information and great history, but 99% or more of the surveys that you will be tasked with resolving don't need those skill sets. So, we're going to focus on how to apply it to modern surveying practice going forward. And if you should ever find yourself needing to resolve a 100, 200, 250-year-old property line or a boundary, then I suggest that you spend many hours absorbing the content of evidence and procedures. I also want to say, as I've alluded to before, that this is a very deep subject. At least one college course could be spent strictly on boundary resolution, and that's how a lot of programs have it set up. A lot of the material that we've covered in this class is minus this module and some other content are packed into one course, and then one course is nothing but boundary resolution or boundary computations or boundary law. Some programs have a course in boundary resolution and then like a part 2 of boundary law where they drill even deeper. So a full year, 2 academic semesters of nothing but how to resolve boundaries. So this module will kind of scratch the surface, hopefully pretty deep. It will be taking a much deeper look. Many modules will look at different examples and approaches and how to apply the different legal principles next semester in Surveying 4475. I will just close this by saying that 2 things. 1, experience is the best teacher. I learned a lot in college about boundary resolution, thought I knew a lot. As I started to apply it as an early apprentice in LSIT, I realized that every case was different, and where I had applied one principle in one boundary resolution, the very next one, that principle was not applicable. It requires some rather finite and acute gut feelings, professional expertise. It's hard to really put your finger on it, but it requires a lot of experience to build that competency level, and that's why state laws in every state require years of experience under the direct supervision of the land surveyor. That's also why in Georgia we've devoted 2 years of the required experience to being in an apprenticeship format where the apprentice must work closely with the PLS to learn these things. It's not really adequate nor healthy for anybody if someone merely serves the minimum number of years going out and driving stakes in the ground or just retracing, half-acre subdivision lots. The second thing is, I've already mentioned it, but the number of scenarios that you can encounter in your career are infinite. Again, I've been doing this for 37 years. I still find where there's something new or some new way to apply something in everyday practice. And of course, no 2 boundaries are exactly the same. So let's start by going back to the board rule. We've covered this before. We've covered different parts that apply to different modules as we've kind of taken this apart and we're putting it together one section at a time. The 2 sections of 1A that I want to touch on are highlighted in the material and on this slide, which is it says the surveyor shall compare and analyze all of the data obtained and make most nearly correct legal determination possible of the position of the boundaries of such parcel. Voila. Surveyors, right here, we are to apply the proper legal principles and make the most nearly correct legal determination of the boundaries of such parcel, aka boundary resolution. This is where it tells us we have to do it and how we do it. And I want to touch on the last sentence in this subsection. It shall be the responsibility of the land surveyor to evaluate conformity with adjacent tracts for overlaps and gores and to report the same on all maps, plats, and reports. So, not just our boundary, but conformity with the adjacent boundaries is all part of the boundary resolution and analysis process. 1B of this rule tells us what to do when, in the event that the land surveyor determines that it is not possible to make the survey of a parcel of land conformable with the record title of such land, or that it is not possible to coordinate the predetermined analysis with the field survey, the surveyor shall explain the reason for his determination and shall denote in indisputable language the source and reason for the corners, lines, and or areas as shown on the plat. So, if you find overlaps, disputes, adverse possession, you find anything that is less than a nice clean survey where the boundaries of the title conform with the boundaries of the adjacent properties and of the lines of occupations, we have to explain this in clear, indisputable language. Many surveyors are afraid that they'll create issues that'll keep a deal from closing and keep them from getting paid, which is a bad practice. We'll cover that next semester. Or that they just don't want to take the time to explain things, or they just don't care, will overlook situations. And that is a violation of this board rule, and it is professional malpractice in many situations. So what are we doing here? I'm trying to approach this from 2 or 3 different angles to really help you gain an understanding of what boundary resolution is all about. The way I have always taught it in my practice, the way it was taught to me, the way that I learned it is, and I've coined this phrase myself, the most defensible solution approach. Because that's a summary of all those other things I mentioned first. There are a lot of ways to skin the cat. There are a lot of ways to resolve a boundary. There are infinite number of mathematical solutions and coordinate pairs that can be created to describe corners and property lines. What do we want to do with that? Well, understand that there are so many solutions, yet there's not one unique solution that is correct and all the others are wrong. There can be many correct solutions derived by different approaches and different boundary doctrines. So the process to get to where we should feel comfortable with a boundary before we turn it loose, set the pins or flag the lines or put out the plat is to determine that we have the most defensible. The most defensible. So for example, if a missing corner is supposed to lie north 55 degrees east 100 feet from a rock, you may go out there and set a pin north 55 east 100 feet from the rock, and that would be a defensible position. You could defend it by saying that's what the deed says. But is it the most defensible? Well, maybe you needed to rotate that bearing to conform to some other lines on the survey. Maybe you found that the previous survey was done very sloppily or measuring along the ground, and you're typically coming up with about 95% of the distance that's called for. Well, maybe instead of 100 feet, maybe that needs to be 95 feet. Or maybe instead of 100 feet, that 100-foot line runs out on a boundary of an existing property. So you need to go determine that existing property line, and maybe that's 102.14. where that computed bearing intersects the controlling boundary. There are a lot of different things, so you have to run through really taking it's a multi-step trial and error process. You find a solution that you like. Maybe you start with the easiest one and then you start attacking it. Where is this indefensible? Where are the weaknesses of this position? Where could another surveyor say that I erred by putting it there? And really, you have to really second guess yourself and play devil's advocate. You go back and forth, and then you find, okay, well, this is really the best way to do this, and this is the best way to establish that. And you could say I've got this against me, but this against me is a weaker argument than that against me. So you just develop a resolution of the boundary that is the most defensible. It will never be perfect. So you just weigh the pros and cons, you weigh the strengths and weaknesses, you weigh the good and bad, you come up with a solution that winds up being the best in your professional judgment. So this is all somewhat subjective. Another thing I want to point out is while you're trying to determine where is the most defensible solution for this corner, keep in the back of your mind, this is the one that you're going to be trying to explain in court. So some surveyors may come up with a really technically complicated, intricate way to resolve a boundary to the third decimal place, whereas you might only be a few hundredths away from simply turning an angle and a distance and driving a pin. I would take turning the angle and driving the pin because it's a lot easier to explain to a jury. Well, it's north 55 east, and then we're supposed to go north 35 east. That's a 90-degree angle. I just turned it, drove it, put it in the ground, and there's where the deed says it's supposed to be. Now, if there's a reason why that does not apply, if that 100 feet is 100 feet more or less until you hit the southern line of Crest Lawn Cemetery, then you need to establish the line of Crest Lawn Cemetery and go 102.14 or whatever it is until you hit that. But realize that you want to be able to explain to 12 non-surveyors in the presence and moderation of one non-surveyor on the bench in a black robe that may or may not understand real estate law. So I've said this, you get a totally different outcome in a boundary case if the 12 jurors were licensed surveyors and so was the judge, because they understand things differently than the 12 people in the jury box and the judge sitting in the panel. So that's where I go with the most defensible solution. That means that you might be having to defend it, not just in court. Before it ever gets to court, there are many steps along the way. Your client may question you. The adjacent property owner may question you. There may be letters from attorneys and demand letters and certified letters, and then there may be filings, depositions. You may have to defend it informally and lightly long before you're sweating it out on the witness stand. So in that, one thing that I want to really stress is many surveyors with very questionable judgment, common sense, and intelligence engage in something called pin farming. Now, what that means is there's a pin out there. The surveyor decides, that pin's not any good. My measurement's better. Let's drive one where I think it ought to go. Before you know it, you've got something like this picture on the right where there's 5 pins in a ½ a foot area. Now, how in the world do you put that on a plat? And how do you know which one's the corner? How do you determine which one should be the corner? How do you address, label, or account for the other 4 that are out there? Do you say half-inch rebar 0.5 northwest, half-inch rebar 0.3 northwest, half-inch rebar 0.4 northwest, half-inch rebar 0.2 northwest, or capped rebar southeast? How do you do that? And this picture in the middle, and both of these, and the other ones in the material, came from the Life of a Surveyor Facebook page. I don't have social media, but a good friend of mine watches this site religiously and sends me these, and so they're public domain. But the ridiculousness of what some surveyors do is it's an embarrassment to the land surveying profession. And I want to talk about it in just a minute. But the picture on the left here in the middle, this apparently is a nail that's driven through the side of a rebar cap at a rebar. So the surveyor that drove this nail says that he is about 3 or 4 hundredths of a foot better, which is well within positional tolerances, and depending on what he was doing, that may not be even as close as he can measure with his instruments technical capabilities. And they drove it, I don't know which one came first, but I believe this short one that says guest was probably there first. And so then this Burdick pin, it was toenailed right here at the base of it. And then a third surveyor came along and said, well, maybe Burdick was a little bit closer, but he was about 3 hundredths off, so let's drive a nail through his rebar cap. I don't know the history over here. I'm not going to go into that much detail on the one on the right, which came from Florida. Pin farming has been known to be a common and real bad practice in Cobb County, where surveyors think that the absolute distance on the plat or in the deed is what controls, period. Everything else be danged. That's wrong on every level. There is no board rule, no requirement, no court case, no boundary doctrine, no textbook that will support pin farming. Now, this splits off into 2 different topics right here. I want to try to cover this fairly quickly. One, going back to the most defensible. Let's just say that what happened here in this picture in the middle is that Mr. Guest set this pin right here. And he thought that was in the best position. All right, well, the next two, Reddick and Nail Driver, they may have determined that Guest put his pin in a position that wasn't as defensible as they thought. You'll find if you analyze a missing corner in great detail, you can you can create a coordinate position by doing a distance intersect from 2 points. You can rotate and create another position by bearing intersect. You can turn record bearing and distance or angle of distance off of 2 pins to create a coordinate position. You can go to a different line on the survey and go angle and distance off of them and create another one. I've literally created 6 to 10 different possible positions of a missing corner sometimes, depending on the complexity of it. So you've got 10 to choose from, and all of them are defensible. You can explain how every one of those 10 positions came to be. And those 10 positions, let's just say there's 5, they might lie. That might be, this picture on the right may well be those 5 different solution possibilities. Once one of them is there, the surveyor has a responsibility to not create confusion, not create legal issues. Even though I might have set the pin where this capped rebar is, if the first one out there is this rebar 4/10 away, unless there are some really extenuating circumstances, I believe that the surveyor has a deep responsibility to hold the pin that's out there, because that elevates it. Even though, let's say that the distance corner is probably the best solution, that's where the orange capped rebar is. And let's say this pin up in the north is that bearing solution, and it's not so good. If there's one pin there, go with that one pin because you can defend it. And another checkbox or another pro in your list of pros and cons is there was already a monument there. That trumps a lot of lower rationales. So the other thing I want to point out is, and let's assume that there's a property owner up here. I'm going to draw some lines in red. They used this northernmost pin. Then someone came in, and now they're using this pin that's over here on the far west. So, and then even furthermore than that, someone else came in and used this orange rebar cap. So that's the purple. So who owns this land in the middle now? Is this a gore? Is this an overlap? What if, and I'm not going to mark this up, but what if different people use different pins? You can have 3 or 4 little overlaps of a few tenths of a foot if you want to try to split hairs. So every time another pin is driven for a corner location, there is a legal implication of a gore and or an overlap that is created because both pins cannot be the corner. Only one position is the corner. So I'll leave pin farming with this. I've been out a few times where the judge or the mediator just wanted to go see, let's go look at this area and see if common sense or some element of possession points us in the direction where this corner should be. If they come out and see 5 pins or 6 pins or 10 pins or 3 pins or even 2 pins in a bunch like this, for one thing, the entire surveying profession looks like a complete band of babbling morons for doing this. We look like a bunch of arrogant snobs who think that my math's better than your math. I'm going to drive a pin through your pin, or I'm going to drive a pin next to your pin. That's what it says to the public, to the judge, to the jury, to the clients, to the realtors, to the appraisers, to the prospective buyers, everybody. But how is a judge or a jury supposed to decide which one of these pins is correct? That's a rhetorical question. Pin farming, don't do it. So how do we do it? So there are some general guidelines for boundary control, which we're going to touch on. The general hierarchy, number one, the highest level of hierarchy or importance or authoritative direction are natural objects such as streams, rock outcroppings, trees. Some court cases have said being natural and relatively immovable objects, they are the least susceptible to being moved, tampered with, or altered. Second, because there are only so many natural objects and only so many natural objects that might be used in a boundary, are artificial monuments such as iron pipes, concrete monuments, or even fences. Third, we come down to measurements, course and distance, bearing and distance. This is to be resorted to when there is nothing else. And rarely is area a controlling element in determining where a boundary is. The area might be controlling if it's like the eastern 10 acres of land lot 82 or the easternmost 12 acres of that property shown on Plat Book 9, page 178. But even then, the area may have been what was intended to be conveyed, and the boundary is determinate upon the area. That is so rare. I've only saw it 2 or 3 times in my career, and 2 of those times was in Alabama, in PLSS lands. So, and even then, say it's a quarter of a section, or nominally 40 acres. If a man deeds the eastern 20 acres to one son and the western 20 acres to another son, there's legal implications that instead of trying to convey 20 acres, they meant the eastern half. So if it's a 38 acre quarter, maybe they conveyed 19 and 19. Or was that junior senior rights and the first son got 20 acres, the second son got the 19 acres that was left? That will often be dictated by the language in the legal description and or the deed. So we have to pay attention to detail and look at these things closely. So in the evaluation of evidence, for a corner to be controlling, it must meet these 3 conditions: be called for, match the description, and appear undisturbed. So if a prior survey or deed says it's a 1-inch open top pipe and you find a 1/2-inch rebar, red flag. That's not the original monument. It has been set by someone presumably since then. You might look closely and find that the rebars drove into the top of that 1-inch open top. You see that sometimes, especially if the open top pipe winds up way down deep in the ground. The rebar is not actually the corner. It's there to help you find the corner. Don't make the mistake of seeing where someone drove a metal stake, a rebar, next to the corner so that you could find it. They left it sticking up out of the ground where you could find it because the open top, the actual corner, is flush with the ground. I saw a lot of surveyors use the rebar, never find the open top. They're pin farming basically, because until they gave that rebar some kind of legal principle, it was just a piece of metal in the ground. So it needs to, a corner to be held needs to meet these 3 conditions: called for, match the description, and appear undisturbed. If you believe the pin's been pulled up and moved, then you can disregard it and set one where you think it was. And the call for a monument is a call to the exact spot originally occupied by the monument at the date of the prior survey or conveyance. So it's proper analysis of determining an original position is paramount. Now, this applies a lot more to older, less precise boundaries that may have been done in chains and poles, but it can definitely apply to corners set in the current era. 2 parties go out and say, there's our corner, that rock, that pipe, that fence line. Regardless of what measurements wind up in the deed, that rock, that pipe, that fence line, it's the corner, period. I had this come up to where an established line was about 200 feet from where it was supposed to be up in Fannin County. I attribute the distance error in being faulty measurements through some really steep mountain land. The opposing side tried to say that no, that was wrong. The deed called for so many poles, which came out to 907.5 feet. I believe it was 55 poles. and that was only 38 poles or whatever it was. So, the line needs to be moved up about 200 feet so that his client got what was called for. But the deed called for 55 poles to a rock, and thence west along Jenkins line so many poles. We established where the Jenkins line was, and using some field notes from the DOT and from some older surveys, because a 4-lane highway was built right over where this controlling corner once sat, we established where the position was. And my client's attorney argued that that was the correct line because that was where their parties had been in agreement as far back as the 1920s or the early 1900s. And this, in court, I brought forth a section of evidence and procedures, widely used treatise. It is admissible under the rules of evidence because it is an accepted treatise. It's not hearsay, even though Don Brown and Walt Robillard were not there. An accepted treatise is admissible in court, and an expert, which a surveyor is in this instance, is totally allowed to rely on accepted treatises. And this is almost an exact quote from Evidence and Procedures, that the call for a monument is a call for the exact spot originally occupied by the monument at the date of the conveyance. So my client won the case. It was appealed twice in 2013. The Georgia Supreme Court upheld the ruling, and so I'm proud to say that I have one case that I testified in and was involved in that was eventually upheld by the Supreme Court of the state of Georgia. So another thing that bears mentioning at this point is monuments that are not called for without some other substantiation constitute nothing more than metal in the ground. I tell my guys, hey, I found a rebar up there. Really? You know what that is? Yes, sir, it's a piece of metal stuck in the ground. That's right, because we weren't looking for a rebar. There's no call for a rebar. We're looking for an axle. We're looking for a U.S. Forest Service manual. We're looking for whatever. If it's not called for, it's just something you found in the ground. Now, if it's near a property line, say within 5 feet, as ALTA standards use as a guideline, then you probably want to show it. Half-inch rebar found 4.5 feet west of the line. You need to show it because somebody might think that it's on the line. Somebody may have thought it was on the line when they drove it to the ground, or they may have been driving to the ground for some other reason. But if it's not called for, it doesn't meet the very first element to be controlling. It has to be called for. If it's not called, it has to be called for. If it's not called for, it just ain't nothing but a piece of metal. Meridians. This is something that we'll study in greater detail next semester, but especially based on some of the comments I've got from some of the earlier assignments about the bearings not being the same on adjacent lines. This freaked some of you out. One of our examples of the subdivision lot in Cobb County that abutted the landlocked line. Plat on one side of the line has one bearing, the plat on the other side of the line has the other bearing. Look, there is no consistent, perfect bearing match mechanism. Going to grid north helps to standardize that. But newsflash, when the new datums come out next year, Grid North 2025 is going to be different than Grid North NAD 83, at least in most of the state of Georgia. And even then, duplicating the bearing is not going to be perfect within a second. So one surveyor may have gone out with a pocket compass, might have been off a degree or two, but it was only good to the nearest degree to begin with, probably the nearest 2 degrees. The other surveyor may have rotated his whole line to match that bearing, or he may have rotated to match another bearing, or he may have rotated it to his compass, or he may have taken a solar observation or a Polaris observation at night to determine a geodetic north. It may be on grid north. Take the pork chop, for example. And about 20 years ago, I was involved in a court case where 2 property owners abutted each other. Tony was retired military. He looked at his plat, he got his compass. He put a line on the ground, built a fence, built a building, built a parking lot. That's my property line. My plat says north 22 degrees west. That's the line. He was wrong. There were corners at both ends. He just didn't find the corner at the northern end. The corner at the southern end was a concrete monument on a highway right of way. Nobody had any questions about it. Calvin owned on the other side. He was my client. His plat called for the same 2 pins without any kind of discrepancy. It was 5 degrees to the east, or 18 degrees northwest. So in court, Tony's attorney argued that he should be over there at 25 northwest, and that's where the line was, and that the other guy's survey was wrong because it comes over on him 7 degrees. And his was first, and his was first, but that's not the point. It was not a junior-senior rights case, as his attorney mistakenly and respectfully ignorantly made. It was the problem. The problem was the 2 corners were there. Tony built like 11 feet over the line at the most. But according to his compass, he had his north 25 or 22 degrees west. I had to explain the difference in bearings. I had to get into magnetic declinations and the variations of a pocket compass. And I used this example graphically. I didn't have these pictures, but I said, just imagine a pork chop. Or in this case, let's look at the spine of one of the green beans. Let's say that it is due north. The pork chop and the potatoes are on the plate. And you simply rotate the plate 5 degrees. The pork chop, the potatoes, and the beans have not really moved in relation to each other. They're in a different place on the earth, but that's really irrelevant. They haven't moved on the plate. You didn't move any food. You simply rotated the plate. Now, if you look at the bearings, they might change a lot. You know, the bearing of this green bean, it changes a lot. It changes however much you rotate it. But the green bean, the pork chops, and the mashed potatoes are all in the same exact location, relevant to each other on that plate. And so it is with property lines. Wherever those property lines are is where they are. How you describe them with bearings is just a decision of what meridian is used. And you usually have several different choices. You could use a pocket compass. You could use a declination chart and a staff compass. The most common practice, I believe, is to use a reference north, where you rotate your survey to match the bearing of an adjacent survey on at least one line. The rest of them will not match perfectly. Or the more common current practice, which I totally support and embrace, is trying to rotate the grid north, because that does not change, other than more than likely will change when the new meridians come out. So consider the pork chop. And don't get tripped up over bearings being different. It's just the way the plate's turned. Another thing that bears a lot of talking about is significant digits. I've gave you a reading assignment that explores this in good depth. It comes from a chemistry book. There are several rules or laws of significant digits. One is that anything to the right of the last integer has no significance. So take the number 8 million. That's 8,000,000. 8 is the last integer. You have one significant digit. You're accurate to the nearest million years. So by the basic rules of rounding, you're within 500,000. So 7,500,001 qualifies as 8 million when your significant digits is 1, and you apply the rules of rounding. There's this old joke to where this tour guide in some big museum is taking the tours around, and he says, this fossil is 8,000,001 years old. Someone said, why? How do you know that so precisely? I mean, that's an exact year. And he said, well, when I started working here last year, it was 8 million years old. So now it's 8,000,001 years old. Many surveying errors result from failure to apply the law of significant digits. There's just lot of ways that this is not properly applied, and I would urge you to become familiar with the rule of significant digits and apply it in any surveying scenario. One example I want to give is, let's just say that the deed says 800 feet. Well, that's basically somewhere between 750 and 849.9, because you just have one significant digit, 8. That's a distance stated to the nearest 100 feet. So if you find the measurement that's supposed to be 800 feet, you find it to be 762.14, you're okay. It's still within the bounds of significant digits. Now, a decimal changes all of that. If it's 800.0, you have 4 significant digits. 8, 0, 0, and the 0 to the right of the decimal. So, if it's 800.000, then you have even more significant figures. It's telling you that's the precision. But without a decimal, like a lot of the older descriptions don't have decimals, or they have to the half, and it's to the nearest half. It's not 0.500, it's to the nearest half. So understand and apply properly the laws of significant digits. So the overview of the process is that once the corners of the boundaries have been surveyed in the field, you've done adequate research, then the measurements are reduced to coordinates and the analysis begins. Refer back to the board rule. When boundaries do not match and are not conformity, we have gores, also known as overlaps, or a hiatus. This is no man's land. There are also overlaps where the same piece of ground's in the 2 different descriptions that compete with each other. Ours is not always to determine whose it is, but we should run a preliminary analysis of, does senior rights apply? Most cases, senior rights can apply or do apply. Sometimes they were just granted out using different descriptions that overlap, or there's such ambiguities in the controlling senior conveyances that you can't tell where it is. Correctly and accurately identifying such areas is a requirement of the state board rules in most states, including Georgia, as well as the ALTA NSPS land title survey standards. The retracing surveyor is a detective, like the famous Sherlock Holmes, a gatherer of facts, an analyst, a scientist, and an artist of sorts. Academia can only teach so much to adequately learn the art of surveying. That is the proper evaluation of field evidence and the proper application of legal principles to boundary location. One needs several years of the best teacher experience. It must be consistently in the surveyor's mind that each survey should be conducted as if it is known that it's going to be contested in court. Because there is an old adage, if you don't treat the survey like it's going to court, it may just wind up there. Another boundary doctrine is that all original corners have the equal weight. Pin farming often starts when somebody says, hey, I feel good about this corner, now let's put the math on the ground and draw pins 3/10 from these other corners. No, there is no way to decide which original corner is right and the other 5 are wrong. You're being a moron when you make that determination. If you can determine that it is an acceptable monument, that it is called for, matches the description, and it appears undisturbed, poof, you're done. The distances yield to the original corner monuments. This applies in a 2-year-old subdivision with capped rebars. It applies to a 200-year-old boundary where locust posts and stone corners were set. So the original monuments control, poof. Throwing out other monuments in favor of math is direct contrast to proper boundary doctrine, and it is not supported by any legal doctrine, and you'll be found in error, probably negligent. Another thing that bears mentioning, imagine your typical subdivision plat. Think about when it was done. Now, something that's done today may be set with RTK, where all the pins should have the same relative positional tolerance. If you find them to be within a 1/10 or 2 in the front, you'll find them to be a 1/10 or 2 in the back. They may have been set 10 minutes apart. Prior to the advent of GPS, or if it's in a wide open area where all the fronts and the backs could have been set from the same instrument point, If it's wooded, hilly country, larger tracts, there's probably a control leg ran along the road. The front corners were set from it. They're probably going to all match with each other. The back corners were probably set from a random traverse line through the woods, setting the pins. There's going to be some error in any survey. The backs probably fit with the backs and agree with each other. The fronts fit with the fronts and agree with each other. I saw pin farms created when some surveyor decided that the original monuments in the back were good, but the original monuments in the front were bad. Because when you turn the angles off the back pins, you miss the front pins by 3/10. So they are wrong. They're not wrong. They are original monuments they control. If you've got 7 minutes of difference in the bearings from the front to the back, or 17 minutes, or a degree, that's okay. Bearings and distances yield to original controlling monuments. If you find a set of monuments in the front that match with each other, you have a very strong preponderance that they are original monuments set by the original surveyor, unless the materials differ. Same thing with the back. So you connect the correct back corner with the correct front corner. I hope it looks like the subdivision plat, but if it's off some, it's off some. I can tell you that in the mountains and in the rural areas, the difference, the positional fluff from the front to the back, I've seen 10 feet in even 1 acre lots. That's okay. The original corners control. Countless court cases confirm that the bearings and the distances yield to the correct monuments. Possession. Often possession can be a strong evidence of the prior surveys. People typically want to possess their land and not get over on their neighbors. They don't want to have any problems. They don't want it to come up. They don't want to spend money on somebody else's land and then have to move something. So possession lines may consist of clearing or cultivation of crops. It may be a mow line where somebody cuts the grass. Maybe a fence, maybe some other active use, a parking lot, the shooting range. Could be a lot of different things. Fences are an evidence of a little bit different flavor that should be often treated separately. Fences often become convoluted in boundary resolution. Fences can be very reliable indicators of property lines, or they can be totally irrelevant to property lines. Take two totally different scenarios. A fence is straight from one end to the other. It's in the vicinity of the property line. Tax map probably drew it to the fence line because that's all the mapper could see. Let's just say that fence was staked out by a surveyor. He put stakes on the line, and the property owner said, I'm going to build that fence 1 foot off the property line. Well, that fence is a pretty good reference monument from now on, that the property line is a fence over, or is a foot over on the other side of the fence. That's great. Let's say that this same straight fence is 22 feet from the property line at the front end and 18 feet off the property line on the back end. It's not even parallel to it. Why is that? Let's just say that Mr. Smith or Farmer John knew roughly where the property line was, but they didn't need that much land. They just were fencing off what was easy to fence in some cows or some horses, or they knew they wanted to stay around 20 feet off the property line, so they knew roughly where it was. They came over and stayed 20 feet off the property line to leave a buffer of trees and vegetation for privacy. There's a lot of reasons that fence could have been built 18 to 22 feet off the line, and obviously those are just hypothetical offsets from the property line. Doesn't mean that the property line moved 20 feet or 18 feet or 22 feet or 22 minus 1. All fences don't have anything to do with the property line. Some do, some don't. There is the instance to where the fence was in existence when the property was divided from the common grantor, and he or she just said, I'll sell you to the fence and you to the fence. Then the fence becomes a monument and it becomes the property line. Even then, fences decay, especially wood fences, and they get replaced or repaired. You know, I saw a very obvious fence through the woods. There it is. But wait, it's off a little bit. And what's this barbed wire hanging out of this tree a foot away? You know, the old fence went through the tree or nailed the fence to the tree. The tree eventually grew around the fence. The old fence went away. The new fence is a wood fence with boards and pickets. It's not in the same place. It's not the fence that was called for in the deed because the fence that was called for in the deed is the one that used to be there, not the one that got replaced with. Encroachments. Don't take the bait. A lot of attorneys, title insurance companies, lenders, numbskulls, and nincompoops, they want to say, show all encroachments. All right, let's go through this. Encroachments and trespasses are legal terms. They are not surveying terms. Repeat that. They are not surveying terms. We are expert measurers and locators of features and objects. We're totally fine to say this building is 8.2 feet over the property line. But what makes it an encroachment or a trespass is that it's a willing trespass. Someone took their things and put it over on somebody else's property without their permission. That's an encroachment or a trespass. Surveyor has no idea if party A told party B, hey, put your building over here, I don't care. Now it's permissive. It's not an encroachment anymore. It never was an encroachment. I saw situations to where someone needed more room than they had, and the neighbor had lots of land, and the neighbor went and talked to the landowner and said, could we fence in our backyard over on yours? I'll move it if you ever want me to, but I want to have enough room for a trampoline for my kids or for a garden for my wife. And the landowner says, yeah, sure. The property line does not move. That is permissive. That is not adverse. It cannot ripen in adverse possession. It was not hostile. It was not a trespass. It is not an encroachment. If the fence is 4 feet over the line and the yard is over there with it, show it, report it. Say the fence is over the line, show it. Don't hide it. But don't call it an encroachment unless both parties come out and say, that's my line. I put the fence over there. No, you came over my property. You're trespassing. If you hear with your own ears the people say this, then you can probably call it a trespass, but you may still have to explain it in court. Let's take it a step further. If it does wind up in court, and you've said building encroaches 8 feet, the party who's wanting it removed, who's jumping up and down, who says yes, an encroachment, you're going to be their buddy. That's probably your client. They're going to pat you on the back. Guess what? The other attorney is going to drill you down, undress you, and embarrass you. Because they're going to ask you, how do you know it's an encroachment? When was it built? When was it placed there? Who owned the property at the time? Did they talk to each other? You have no way of knowing. You weren't there. You're a surveyor. You're not a historian. You're not a neighbor. Don't take the bait. You can call it a potential encroachment, a possible encroachment. I try not to even do that. Unless I really have a good idea that, these people crept over the line. Nobody knew where the line was. Possible encroachment, apparent encroachment. But I'm not going to say it is an encroachment with certainty because I don't know. They may have said, yeah, come on over, I don't care. Another thing that happens is the common grantor owns the house and the land, has it cut off. The cutoff line goes through the yard and misses the fence. The fence and the yard were not an encroachment when they were put in. They're not an encroachment now. They're just misplaced improvements and occupation lines. So unless you can testify to something and support it and substantiate it, don't put it on your plat. Don't put it in your reports. You simply should not do it. To call something an encroachment is to express a legal opinion. We are surveyors, not attorneys. Proportioning. Here's another doctrine or approach that you'll see on licensing exams. It's very simple. My example is if a line is supposed to be 100 feet wide and there's 3 100-foot wide lots cut off of it, and then you come back later, nothing else has happened, no occupation, no pins in the ground, just the 2 corners, 300 feet apart, and you find out that they're 303 feet apart, then each lot, because it's part of simultaneous conveyance, this proportioning only applies in a simultaneous conveyance or in PLSS sections and aliquot parts. So in Georgia and the colonial states, this will really only apply to situations where simultaneous conveyancing exists, not sequential conveyancing. Because if the person got 100 feet on the east, 100 feet on the west, the person in the middle might have got 103 feet. But if it's 303 feet wide, everybody gets 101. If it's 297, everybody gets 99. If it's 299.7, everybody gets 99.9. But listen, this is in a lot of exams, this is in a lot of textbooks. It's low-hanging fruit. It's easy math. It's an easy concept to grasp. However, it rarely actually applies in real life. Many articles, many books, many court rulings say that proportioning should be used only as a last resort. There's nothing else out there. There's no other way to establish these corners. And that's your last resort. And it should only be applied between confirmed original monuments. If you've got a 100-year-old plat that shows a bunch of lots with 65 feet of road frontage in DeKalb County, like I just did, and you've got two lots that are 64 feet apart, and you got an open top pipe and a rebar, and then you skipped 3 lots, it should be 195 feet. Well, 198 feet up, hypothetically, 3 extra feet, you find a capped 1/2-inch rebar and then a crimp top pipe 65.3 feet further up the road. Proportioning may be my last resort in that situation, because if I don't have anything else, because there's nothing else there. But it's really improper because the shiny rebar and the crimp top pipe are not original monuments from 1914. Probably some open top pipes, maybe some wood posts that have rotted. A lot of surveyors did not set lot corners back then. It wasn't really required. People would measure from block corners and drive temporary points for the sake of their construction. Occupation lines in those situations are usually the controlling legal element, because it demonstrates where adjacent owners acquiesced to and recognized a known line to a monument that no longer exists. So, proportionate does not apply in that position if there are existing occupation lines. The occupation lines would control as a higher level of evidence of where the original monuments once stood and would be the most defensible solution. That's all, folks, for now anyway. This is a broad overview and introduction to the general principles. I hope this ties into the reading. This gives you a good glimpse as to where to go, but I hope you understand there's a lot more to it. We've just scratched the surface. Thank you.